And Your Honor, I'm gonna tender that as an exhibit once
Okay.
I lay the foundation.
Just go over that with Donna while we're off record. No, I just have 6. That's the most I have. Mike, you have 6 exhibits?
Sir?
We're just talking off record. You have 6 states exhibits?
Mm-hmm.
We're trying to number this one. That's all.
I think I had 6.
That's what we have 6. So this would be 7. Okay. Again, we're just doing that off record just to make certain we're all on the same page. So you can take that one you got there, Mike. Just mark it as state 7.
I'm done with it.
You're ready?
Yeah.
Okay. Thank you. All right, Ms. Sexton, whenever you're ready, he has finished reviewing the document.
So knowing that this happened a while ago,
Mhm.
as you said, it's been a long time ago and you didn't remember exactly. Was your memory kind of refreshed when you saw this transcript of a telephone conversation?
Yes, a little bit.
Okay. The main issue that I'm gonna ask you about, I'm not gonna ask you about everything, but basically, as a union rep, were you engaged in any part of the process with the grievance?
No.
You were not? Okay, so in this, you reference an email that Jay sent that you saw.
Mhm.
And can you tell me what you saw in that email based on this conversation that your memory is refreshed by?
She just gave Miss Marshall just gave a statement of what happened that she had to send to Brenda.
Okay.
Brenda is the union rep for the clerks on the
Okay.
clerks at that time.
Okay.
She was the union rep for the Griffin office because we didn't have a local rep, so everything had to go to her. So she asked for a statement, and LeJay sent a statement to her or something like, I think it was a statement. Yeah, it was a statement.
Okay.
Just a brief synopsis of what had happened.
Okay. And per that email, you saw per this telephone transcription, you saw that email, correct?
I did.
Okay. And can you tell me basically what that email contained using this transcription as a refresher?
I'm going to object to him testifying about what some email said from somebody else. That would be, number one, would be hearsay. And if she got an email that she wants him to testify to, then she needs to present the email. But for him to start talking about what some email said from somebody else in the evidence that we don't have opportunity to cross-examine, I think that's hearsay. So I'm going to object to it on that basis. And on the best evidence, because if she got this email, she wants him to testify to some email he saw, she need to bring the email.
She did not get an email. That's the whole point. My client did not get a copy of an email.
But who said he
Email.
got the
Hold
email?
on. Hold that second. This conversation, y'all are, again, there's no jury present, so I'm gonna dig into this a little bit so I can figure out, I'm still not entirely certain what we're talking about. You had a conversation with Ms. Gooden. That's what that transcript is? Is that correct statement?
Yes,
Okay. And in that conversation, you all were discussing certain things, and one of which was an email that I guess went out.
yes.
And who is it from and who is it to?
Her name is LaJ Marshall,
Okay.
and it was going to Brenda. I can't. Story.
Okay.
I couldn't
So,
think of her last name.
I don't need her help. So
sorry.
Deborah, you need to talk to her and tell her that's the second time she's done this since we got back from lunch. If she does it the third time, we're gonna have a conversation she's not gonna like.
Yes, sir.
Okay. Only one of us can do this, and it's not gonna be her. All right. Sir, will you try to answer that question again?
Okay, LaJ Marshall sent an email to Brenda on Brenda request, just about
Okay.
what happened, basically.
And then if you were to testify about this, what is it that you would have knowledge about?
Nothing.
Okay.
I was at work that day, but I wasn't I wasn't.
That makes sense.
Yeah, I found if I can. When I got off work that day, Kenya called me.
This makes sense. Okay, I'm going to stop you there.
Okay.
Mr. Kendall, what I'm going to do is I'm going to allow this, but I'm going to make my ruling after the fact. This is not a jury. This is me, and I will rule at the end of this what I'm going to do with it. Because I think there's some pieces in here that are valid, and I think there's some pieces in here that are not. And I'm just going to let him, instead of putting him in a really awkward spot of him having to tap dance through it, I'm just going to let him testify to it, and then I'll sort the pieces out.
Yes, sir.
I think there are very likely some valid objections from you, and I'll do all that after the fact.
Yes, sir.
All right. So I'm going to give him a lot of free reign and give you a lot of free reign to ask whatever questions you want. And that'll make his testimony easier for him. And then I'll sort out what is allowed and what's not when I make my final decision. Ms. Sexton, the floor is yours.
So I'm sorry, I'm going to try to do this as right as I can.
Okay.
You had an opportunity to read this transcript to refresh your memory, right?
Right.
Okay. Let's start with the basics.
Mm.
You had a telephone conversation with Kenya, is that correct?
Correct.
Okay. And that telephone conversation, by reviewing that without knowing exactly what were the tone of this sounds like a conversation that you would have had with Kenya. Is that correct?
Correct.
All right. Kenya was asking you, as a union rep, if you had seen some documentation. Is that correct?
No.
She
No,
was
the way.
asking you if you, I'm sorry, she was asking you if you had seen an email. I'm
Yeah.
referring to that as documentation.
Okay.
Is that correct?
The initial phone call was, she told me, what was going on, and this phone call wasn't the day of. It was a couple of days later.
Yes, exactly.
And what was going on, it was a grievance being filed on her behalf about what happened.
Correct.
She was asking, she want to know, in so many words, was the grievance filed?
Was the grievance filed?
Yes.
Correct.
So, like I said before, Brenda Story was the union rep at the time for the office. She had to handle all grievances, all of them. Well, LeJay was the union steward, but Ms. Story was handling this one right here, this particular incident right here.
Mhm.
So she wanted to know was it filed?
Correct.
Was an email sent out? And I told her yes.
Yes.
Brenda, they was in correspondence through email, and Brenda asked LeJay to send an email on her what she saw what happened. So
Right.
that was the point of the conversation.
And thank you. In the email, look at, I think these are times 36-048.
I couldn't answer that question. I don't know what it
I'm
is.
sorry, it says Enrico.
Mm.
Halfway down the statement
Mhm.
at, I guess it's 36-048. Do you see that? After Enrico, it has Enrico, Kenya, then Enrico. Right here. Can I approach?
Yeah, just
right here.
Okay.
Can you read that for me?
Wait, yeah.
I'm sorry, I'm sorry, I'm
Yeah.
rephrasing.
Yeah, all right, good
Can
catch.
you read that? Can you read that line? And then can you tell me, based on that line, if your memory was refreshed of whether or not you saw an email?
Well, I already answered the question. I did see an email.
Okay. And can you tell us what you remember that email said?
Well,
No, I can't.
Okay.
I can't tell you
I was about
verbatim
to
what the
say,
email said.
I think your objection is gonna get resolved here, so go ahead.
I can't say verbatim what the email said. Again, like I said, Brenda asked her, Miss Marsha, what happened that day. She put her point of view of what happened that day.
And I'm understanding that you can't tell me what the email said, nor am I asking you. Do you remember if the email related the events of the day? What happened in the incident?
I mean, the email had, if I'm not, it had a lot of stuff in there that happened. You know, from the incident, from earlier that day, from the window situation. Just had a lot of stuff in there. I mean, if you want me to be specific, I can't, because, like I said, it was 2 years ago. I can't remember an email from 2 years ago.
Okay, but this is a transcript of your words though, right? Is this a transcript of your words?
Again, that's 2 years ago. I know I talked to Ken. I can't say and say, I said these exact words. I can say probably paraphrase, but I can't say and say with the exact wording that I used, because again, that was 2 years ago. I mean, you can ask the question, it's going to be the same.
After reading this email, after reading this transcript, which would help you recollect what happened 2 years ago, did you relate that Miss Johnson had put her hands around the victim's neck based on this transcript?
No, because I never said Miss Johnson put her hand on her neck. I wasn't there, like I told you. I was at work, but I wasn't in the building.
All right, Your Honor.
Okay. Mr. Kendall, Cross?
No, sir, yeah.
All right. You are free to go or stay as you please.
Okay.
So you've completed your testimony and your responsibilities to this court. So you're finished.
For the rest. I'm done.
Yeah, you're done
Okay.
altogether.
Okay.
So you're welcome to stay in the gallery, or you're welcome to go back to work, or you're welcome to do whatever it is you would prefer to be doing next. Home. Okay. And the answer is you are free to go home.
Thank you, sir. Thank you for coming.
All right. Thank you, Ms. Spitz. All right. You may call your next witness.
I'm done.
Okay. All right. State is rested. Mr. Kendall, did you have enough time over the lunch break to speak with your client and to
Yes, sir.
decide what y'all wanted to do this afternoon?
Yes, sir.
All right. And I'm just going to do my part of this, which is my responsibility, ma'am, is to say that you have the right to remain silent. And if you choose to exercise that right, the court will not hold any silence against you. But if you choose to testify, you'll be called up here to testify. Mr. Kendall will ask you some questions. Ms. Sexton will get to ask you questions, and you'll be required to answer those questions as long as, of course, they're allowed by Georgia law. Do you understand, and have you talked fully with Mr. Kendall about your right to testify or remain silent?
Yes, sir.
Do you have any questions you want me to answer before Mr. Kendall announces for you?
No, sir.
All right, Mr. Kendall, what's y'all's announcement? Testify or
Well,
remain silent?
I'm going to, I want to make my motion for the rest verdict first.
Oh, sure, we can do that.
Yeah, I want to cite these two cases. First,
I'm ready.
First in the state, 145 Georgia Appeals 328, and Reeves versus the state, 128 Georgia Appeals 750. One's a 1978 case, the first one, the next one is a 1773 case.
What's that second site again? The second site?
128 Georgia Appeals 750.
All right, thank you. I typed it in wrong. Yeah, I got it now.
In his Riddle case, it held that in every assault there must be an intent to injure. The test is, was there a present purpose of doing bodily injury. And in the second case, holding was, it says to constitute an assault, no actual injury need be shown, it being only necessary to show an intention to commit an injury coupled with an apparent ability to do so. And, as I said in my opening, this section says she only had to prove one thing for an assault, that there was reasonable apprehension on the part of Miss Gooden that she was about to receive a violent injury. But she also has to indicate that there is an intent on the part of Miss Johnson to commit and doing this serious bodily injury. There has been no testimony here to indicate either one of these things, really. Whether or not Miss Gooden had a reasonable apprehension that she was about to receive a serious injury, or a violent injury, shall I say, and make sure I get my words right, a violent injury, nor has she proven any evidence that Miss Johnson intended to commit a violent injury upon Miss Gooden. And when I asked Miss Gooden that question about how close she was she being choked, she said no. And did she make any kind of demonstrative attempt to move back, flee, get away, prevent her from being a violent injury being committed upon her? She said no. She was just sort of, just stunned and didn't know what to do and didn't know what to think. And she just kind of just froze. And the other key point, I think, in going to Miss Johnson's intent was that Miss Gooden testified that Miss Johnson didn't come up to her to start any kind of conversation. She never approached Miss Gooden as if she wanted to commit some injury on her. She said, Miss Gooden, that is, that she was walking by and Miss Ellerby and Miss Johnson was standing there. She initiated this conversation about what had transpired that day. And then Miss Johnson made this gesture and put her hands around her neck. So it wasn't as if Miss Johnson had some intention. I'm thinking about, I'm going to go over here and I'm getting ready to confront Miss Gooden about what happened today. That would, of course, go towards her intent. The other thing I think is very instructive here, about the way this case has been prosecuted. In the accusation, it basically alleges a battery, but it is styled as an assault, which I think is indicative, Your Honor, that the state doesn't even believe itself that Miss Johnson actually put her hands on Miss Gooden, because if they did, they would have alleged a battery. And it would have been much easier, I think, in that case, to prove that Miss Johnson touched her. But the fact that they didn't even charge her with a battery in this case indicates that they don't even believe that Miss Gooden got touched. They're relying on strictly that she made this gesture as the assault. But if she never intended to choke Miss Gooden, and Miss Gooden said she didn't get choked, but she was touched sort of slightly, there's on anybody's part that I have seen any evidence they have presented that Miss Gooden actually thought that she was about to receive some violent injury. She came back to work the next day and she filed this grievance a couple of 3-4 days later. They're making a big deal out of it for some reason, I don't know. But there's no intent and there's no reasonable apprehension of a violent injury taking place. So the two key elements of proving this case, the state has failed to provide any evidence of either one of them. And I think it's also instructive, y'all. They came up with, on Friday, these witnesses' statements, these videos of the witnesses. Miss Sexton obviously probably hadn't seen them, because if she had seen them, she probably would not have put those people's names on her witness list. So she probably just saw it Friday. I just saw these testimony. I mean, these video statements from the state's witnesses. And the fact that she doesn't want to call them, I think, is pretty indicative of the fact that they are not going to help the state's case in any event, in any manner, in any shape, in any form. And I think the court can take judicial notice of the fact their witnesses that they subpoenaed, they don't even want to call. We could go through all those long videos and spend another hour or two looking at these videos. But I think, you can take judicial notice of the fact that they didn't present it. They don't want to call their own witnesses, because Friday, after Miss Sexton got a chance to look at these videos from the people they had subpoenaed, she realized that these folks were not going to be in support of anything that they were trying to claim in this case. And in fact, they were going to say the exact opposite, that there was no reasonable fear that Miss Gooden was about to be choked or anything else, any other kind of violent injury. And they were going to testify that there was no intent on the part of Miss Johnson to commit a violent injury to Miss Gooden, and that's why they were called. So on those basis, Your Honor, I think a directed verdict in this case, for lack of any evidence in front of the court that would reasonably, that the court can believe beyond a reasonable doubt that Miss Gooden apprehended that she was about to receive a violent injury, and that Miss Gooden, Miss Johnson, intended to commit a violent injury against Miss Gooden.
All right, thank you so much. All right, any response from the state?
Your Honor, I'm not sure what law we're looking at, because the intent was to create apprehension of an injury, which absolutely 100% happened. Ms. Johnson is a supervisor. She's a postmaster. She is in charge of this woman's employment, her livelihood, her schedule, her work environment, everything else. She is not a friend. She is not a family member. They are not familiar. My client did not testify that she approached Ms. Johnson. They were working something out, and she was walking alongside Ms. Johnson. Ms. Johnson then turned and put her hands around my client's neck. Now, there is testimony that says, from the people that were there that have not been called, that will say, I saw the gesture. I was not close enough to see if there was skin-on-skin contact. That is not a statement that says there was no skin-on-skin contact. That is, the angle I was looking at was not skin-on-skin contact. I am not sure in whose world a supervisor can come up to you after you have made a mistake and you have had a history with this person, and come up to you in an environment that has zero tolerance and walk up to you and put your hands around their neck and say, I could choke you. It's laughable that the defense attorney is arguing whether or not his client said, oh, did she say, I'm going to choke you versus I could choke you? In the moment, I am supposed to decide whether someone approaching me with their hands around my neck and telling me that they are going to choke me, that you are going to depend on words versus I'm going to versus I could. My client left there and said, I am done. She was afraid. She didn't want to be there. She made contact immediately with the union rep. Immediately told her about it. We have documentation for that. The grievances were not timely filed. They took forever to get filed. My client, my victim, Miss Gooding, was reaching out to people and going, where are the grievances? Where are the emails? Where are the statements? You don't do that if this is a joke, if this is casual. It was an intent to create fear of an injury, and it did. I don't know how often somebody can come up in close proximity to you, and whether they lay their hands on you or whether they make a motion of putting their hands on you, that you are not supposed to be afraid that in a nanosecond, all they would have to do is close on you.
Okay.
You are afraid. And there is no reason for a directed verdict when my victim gets up there and says, I was afraid. I was afraid she was going to hurt me. It is reasonable that I was afraid she was going to hurt me. The intent is, how am I supposed to prove her intent when her actions prove her intent? Her actions prove her intent. You walk up to someone who is your employee and you put your hands around them. And they are supposed to think that they are not supposed to be afraid. And then you cloud the issue by debating whether or not their neck was injured or whether their head was injured. It doesn't have to be injured. It has to have the apprehension of an intention to do a serious injury, to do a violent injury. And if putting your hands around someone's neck where you could deprive them of their life is not considered a potential violent injury, I do not know what is. Maybe aiming a gun at them. But I tell you what, if someone came at me with their hands around my neck and told me that they could choke me, I would be afraid of grave and violent injury. And I would have no reason to think anything else. No reason to think anything else.
Okay, thank you. All right, so as this is a directed verdict motion, the standard, as you all aware, is the any evidence. So is there any evidence in the record that's been given to me this morning to support simple assault? And as we've been discussing at length today, the simple assault elements are that that someone commits an act which places another in reasonable apprehension of immediately receiving a violent injury. The key testimony that supports the any evidence to get us through from directed verdict to the end of the case, at which point I will be then applying proof beyond a reasonable doubt, is specifically Ms. Gooden's testimony as to the series of events and how Ms. Johnson did place her hands around her neck and then said, I could just choke you. And then Ms. Johnson did feel threatened. So by the any evidence standard of this moment in this trial, the directed verdict is denied. Again, at the end of the trial, for the non-lawyers, non-folks, the end of the trial has a different standard, and I will make that decision at that time. All right, so that's denied. Mr. Kendall, anything else before we step forward into the next phase?
No, sir.
All right, are you prepared to announce if your client wishes to testify or remain silent?
Yeah, she's going to testify, Your Honor.
All right, perfect. All right, ma'am, you can come on up. Mr. Kendall's going to swear you in. And then Ms. Sexton will cross-examine you in the same way you've seen your attorney cross-examine the state's witnesses.
Yeah.
Oh, I'll take that. Or you can give it to Donna.
Don't raise your hand, Ms. Johnson. Do you solemnly swear or affirm the testimony about to give in this hearing before Judge Stacker today is the truth, whole truth, nothing but the truth?
Yes, sir.
Have a seat, please, ma'am. Please state and spell your name for court, please.
Okay, my name is Fenetra Johnson, Fanettra Johnson.
Spell it for me.
Oh, Johnsson.
Miss Johnson, how you currently employed?
I'm currently employed with the United States Postal Service
How long you been employed with the United States Postal Service?
for 25 years.
All right. So how long have you worked here in Griffin?
Since 2022, so around about less than 3 years, because for the last since September, I've been in another office.
Right. So you came to Griffin Post Office in 2022.
Yes, sir.
All right. We're talking about the main post office over here on 8th Street.
Yes, sir.
You came to Griffin, what was your capacity?
I was the officer in charge.
Explain to Judge Stacker what that means.
Okay, an officer in charge is someone that is filling the position of a postmaster while the original postmaster is on detail. So the original postmaster, Miss Melissa Ward, was on a detail. So I was just filling in for her while she was on her detail.
So you are a postmaster at another location.
Yes, I was awarded another position in Ellenwood, but I never went there. Yeah, they just awarded me the job, but I actually worked. I was on a detail from Ellenwood. I was on a detail from Ellenwood to Griffin.
So I take it, I see in some of these statements that the post office refers to these post offices as stations.
Yes, sir.
So your station where you were the postmaster was in post office in Ellenwood.
Yes.
But because in Griffin, the postmaster, the person who holds the title of postmaster was on a detail somewhere,
Hmm.
you got moved to Griffin to be in charge.
Yes, sir.
But you're not technically the postmaster in Griffin.
No, sir. Not at that time. Not in
that time.
2022. Yes, sir.
2022, but
Yes,
you
sir.
were in charge of the building.
Yes, sir.
Now, when you came in 2022, was Ms. Gooden employed there?
No, sir.
Okay. When do you recall that Ms. Gooden start working at the Griffin Post Office?
Around 2024.
2024.
Yes.
And she testified that she started working in June. I think she said June 1st of 2024. That consistent with your recollection?
Yes, sir.
All right. Now, what was her position when she came to the office in Griffin?
She was a clerk.
So what does a clerk do?
Well, a clerk does several things. They just depending on the job description. They could be sort the mail in the morning for the carriers. They can wait on customers at the window. They can do the P.O. box. They can do bulk mailings. That's like if you have a large mailing. So they can do several things, but mainly their distribution and sales. So they can work the window and do distribution in the back.
All right. So you as the person in charge of the Griffin office in 2024, when Miss Gooden started working there,
Mhm.
was it your responsibility to hire her? Or explain to the judge how that situation worked.
Okay, no, it wasn't my responsibility to hire her. I'm not part of human resources. Long time ago, they would let the postmasters or OICs hire people, but all of that is done through human resources. So when Ms. Gooden came, she bidded on a job that was on e-reassign. Okay, e-reassign is for employees that have been accessed or they don't have a current, like she was saying, they're consolidating offices. So they have to find these employees somewhere else to go. So Ms. Gooden bidded on this job. She applied for this job. And I guess due to her seniority, she was awarded the job.
All right. So they don't have to come to you and get your approval for her to work there.
No, sir.
So when they get assigned to a post office like Ms. Gooden did, got assigned, she bid on the job, she won this bid, and she got placed in Griffin,
Mhm.
you have to work with them irrespective of anything. Am I right?
Yes, sir.
You don't get the chance. You don't have to interview her and say, I don't like this lady and I don't like her attitude or anything. You don't have the option of saying, well, she can't work here.
No, sir.
So when she got there in June of 2024, and
Mhm.
this incident happened on August 29th,
Mhm.
she had been there almost 3 months, am I right?
Yes, sir.
All right, so in those 3 months from June, July, and August of 2024, had you and Miss Gooden had any sort of confrontations?
No, sir.
All right. When Miss Gooden says that she was being discriminated against and you wouldn't speak to her and you would walk by and not be cordial towards her and anything,
Mhm.
did anybody ever, did she ever confront you about that, or did she ever come to you and say, well, this is a hostile work environment here in Griffin, and I'm not really comfortable here?
No, sir. In fact, there were numerous times where I worked with Miss Kenya because she was a single mother. I adjusted her schedule at least, I know, one to like 30 days so she can get her daughter to some type of cheer competition because she was a single mother, and I sympathized with her because I was a single mother as well. So when I became promoted, I always said, I would work with my employees, especially if they had a schedule conflict. So no, there wasn't any issue because, like I said, I would work with Miss Kenya. The only issue there was is just following the chain of command. Sometimes she didn't want to speak to the supervisors. She would try to go past the supervisors and come straight to me. She would send me emails in the morning saying, hey, I see you're not here. Can I come in at this time? Can I come in at this time? That's what the lead clerk is for. I don't do the schedules. The lead clerk is responsible for the schedules that's assigned to the clerks. But no, it wasn't any instances because, like I said, I worked with Miss Gooden in regard to her schedule several times.
Okay, so let me just back up 1 second. Uh, is the official title when you're in charge of one of these buildings the postmaster? Is it still the same thing?
Yes, sir.
So how long have you been officially a postmaster?
Since 2021, I was a postmaster of Barnesville.
Okay.
Yeah.
So before you got to Griffin in 2022, you'd already been a postmaster for about a year.
Yes, sir.
So before you got to be the postmaster, what was your job?
I was a clerk.
You were clerk.
Yes, several years.
Okay. All right, now let me move on forward here. On this incident on the 28th, you heard Ms. Gooden testify that there was an issue between her and Mr. Blakely about whether or not somebody could mail a bottle of perfume. Real briefly, explain to the judge what's that about?
Okay, so real brief, when it comes to perfume, it is a flammable liquid. So we have to be very careful how we mail those items. Certain ounces, they can go on a plane, but certain ounces can't. So when it comes to a large volume of perfume, it can be mailed, but it has to go ground rather than going through an airplane. Because we use the airplane as, if you've ever mailed, it's priority mail. So when it goes ground, it has to go from city to city, state to state, because it is a flammable liquid.
Okay, so that was basically the dispute or the question that Mr. Blakely and Ms. Gooden were having about how to ship a bottle of perfume.
Yes, sir.
This was on the same day, 29th, I think.
Yes, sir.
All right, so they got into a little dispute about that and had a few words, right?
Yes, sir.
All right, and then we had this issue about the money.
Mm-hmm.
Somebody wanted to use a card and pay cash for some items. And as Ms. Gooden said, she ended up taking the person's cash and striking this person's card for the entire amount of the transaction. Am I right?
Yes, sir.
So she ended up with over $1,000 extra money in her drawer.
Yes, sir.
At the end of the day.
Yes, sir.
All right. So whose responsibility initially when a clerk has some discrepancy in their money or whatever, whose responsibility is it initially to address that at the time before the clerk leaves?
Either the lead clerk or the supervisor.
Okay, so at what point in time did you get involved in this particular? Well, let's back up. Did you, when Miss Good and Mr. Blakely had this dispute about the perfume, did you have some knowledge about that particular incident?
No, afterwards. I wasn't at the window at the time.
So you didn't know anything about this going on between Miss Gooden and Mr. Blakely at the time it happened?
No, sir.
You heard about that later?
Yes, sir.
All right. So at what point in time did you get involved in this discrepancy about the money?
Okay, so with the money, I believe, she was counting down her drawer and she noticed that she had an overage. So she contacted the supervisor, Sharika. I guess Sharika wasn't giving her the correct answers or she didn't feel comfortable with Sharika. So she approached me and came to me about the money. So that point, I went to the window, and I said, well, the first, just going through the steps that we should take first, so we can account for the money. Because once you close your drawer, the system is going to ask you for a certain amount of money. And she was trying to overtalk me, and it was just a long day with that. So eventually we got to it. We counted down the money. We put the excess money in a safe. And we had to investigate through her receipts and everything like that to see where, the discrepancy was.
So that particular day, you could not figure out exactly how she ended up with over $1,000 extra in a drawer?
Right, not that particular day, but I knew that the lead clerk was coming in. She was coming in a little bit later, and I knew that she could look at the paperwork and see kind of like what happened with the money.
Basically go back and do an audit of the transaction and then figure out where the money came from?
Yes, sir.
And eventually you guys ended up doing that, right?
Yes, sir.
So that particular day though, before Miss Gooden left, you had not actually figured out exactly where this excess money had come from, am I right?
That's correct.
All right, so at what time of day are we talking about here?
Between maybe 1 p.m. and 2 p.m. around that time.
So what time was Miss Gooden getting off that day?
Between maybe 2 and 2:30. I'm not sure because she was a flex. So at the time, so I'm not sure about her schedule for the day. Because like I said, I'm not responsible for the schedules.
So when you say she's a flex, you mean she works what?
We can change her schedule from day to day. Basically, a flex clerk is if someone is off, then they'll cover that off day or whatever the need is, or whatever the need for that day is. So if we have someone that maybe the dispatch clerk is off, then I could put the flex clerk in that time frame. Or if I need someone in distribution, if we're short that morning for distribution, I can put that clerk, the flex clerk, in that time frame. If we're short on the window for the day, I can put the flex clerk in that time frame.
Okay, so who made her flex?
She bid it on that job.
Okay, so she knew what it was. You didn't make her flex.
No, sir.
That's something that she knew about when she took this job in Griffin.
Yes, sir.
That her schedule could be possibly changed around.
Well, to my knowledge, she did have an issue when she came about the flex position because she said she didn't know it was a flex. So she filed a grievance about that as well. And I believe they determined that it was a flex position, so we could still keep her in the flex position.
Okay, so well, she didn't understand she was a flex until after she got there.
I believe so. Yes, sir. She filed a grievance about it.
Okay.
So,
All right. Now, once you're this same day on the 29th when the incident happened, and you came up with this discrepancy and you're trying to figure it out, tell me, before Miss Gooden left, when she said she walked up, you were having a discussion, and she brought up these incidents that had happened that day. Explain to Judge Stafford what happened.
okay, so on that particular day, she had counted her drawer. She was about to leave for the day. And she approached me and Sharika, which is the supervisor. Sharika
That's
was,
Miss Ellerby.
yes, sir, Miss Ellaby. She was standing right next to me. We were at the supervisor's desk on the main workroom
In
floor.
the post office, just in the post office, where are we talking about? Is it back there in the back somewhere where people?
Yes,
can
sir.
see?
Yes, sir. Where the carrier cases are, where they sort the mail, they process the mail. So this was in the back of the building.
Okay,
Mhm.
so go ahead.
Okay, so she approached us, and like I said, it was a long day, and she approached me. She had that look on her face like she had just drained, emotionally drained.
Okay,
Wh-
let's stop right there. Put a
Okay.
comma right there. So when she came up to you and appeared to be emotionally drained, at that point, did you know anything about the incident between her and Mr. Blake?
No.
You hadn't heard that either?
No, not yet. Not at that time. That was afterwards.
Okay, go ahead. keep
Okay.
going.
So then she came up to me, and before she, We were about this ways apart, and I did the gesture.
Wait.
Huh?
When you say this way, then you gotta
Oh,
explain, you gotta stay.
from the
I'm
podium.
thinking now what you're saying, when you say this, you gotta.
Okay, I'm sorry. From this bench right here to where the podium is, she was walking towards me.
Podium where I'm standing.
Yes, sir.
Okay, give me an estimate. You know, I may be good with feet, but how much distance do you think is between?
I'm not good with that either.
You can count the carpet squares.
Okay, maybe 10 carpet squares.
Okay.
Okay, all right.
And she was approaching me. And like I said, she did look frustrated. Everybody was frustrated that day. It was a long day. And I have to give Miss Kenya, she is adamant about her money. She wanted her money to be right. Nobody wants to pay a overage or no, well, a shortage. And nobody wants to be responsible for a overage because it does, the appearance of the post office doesn't look good. Especially when you've shorted a customer. And even though this young lady had enough money on her card to cover, just imagine if she didn't have the money to cover, all the things that the post office could have been responsible for as far as overdrafts, and it could have been a very huge issue. But anyway, she was coming up to me, and I did the gesture and I said, "See, Kenya, we got it done. We got it done." I know today I can't remember the actual words I said, but I do remember saying, "We got it done, Kenya, we got it done." And then me, her, and Sharika, she probably don't remember it. We start kind of, just laughing about it. And she still looked frustrated because we all were frustrated because she didn't want to listen to Sharika. So at that time, I had to come to the window because technically I'm not really supposed to get involved in those type of things, but I know that this is a big issue, so I had to go ahead and get involved.
Okay, so when Miss Gooden left, you really had not figured out what this. I think she said it was $1,050, $1,150.
Yeah, it was over $1,100.
It
Yes,
was over
sir.
$1,100
Mhm.
discrepancy. So you had $1,100 extra in cash in the drawer that you couldn't account for.
Yes, sir.
So when she left, you really didn't know, and she didn't know where that money came from.
Correct.
All right. So after you made this gesture
Mhm.
and everything, did you actually put your hands on her?
No, sir.
Okay. So how close in proximity did your hands come to being around her neck? She said you put your hands on her neck as if you're going to choke her.
Okay. So by the
explain
time,
to Judge Stafford what you did.
okay, so by the time she got up to me, it probably was about 5, maybe to where this young lady sitting.
You talking about the court report?
Yes. Mhm.
So she might have been what, about 4 or 5 feet from you?
Yes. Well, we're all in a circle, me, her, and Sharika, but we weren't like in close proximity to each other.
Okay. And then, so how close did she come? She said you put your hand on her throat. So in that case, she had to be you had to be in her personal space. She had to be in your personal space.
Right.
You're all not that long. So,
Yeah.
okay.
I was not in her personal space.
All right. So do you recall putting your hands close to her neck?
No, sir.
So tell Judge Stafford how far away when you did this gesture.
Mm-hmm. But when I did the gesture, she was walking up towards me.
She was walking towards you.
Yes, sir. From where the podium is, and I'm
where
right
I
here.
am.
Yes, sir.
Okay.
She was walking towards me and Sharika.
All right. So Miss Elder was there, just the three of y'all.
At the time, and I believe LeJay Marshall had walked up. And by the end of the conversation, Miss Nikki had walked in, she had walked up. But it was just the 4 of us.
So who might have been able to hear this conversation?
Miss Sharika.
Just Sharika.
Well, Miss Ellaby and Miss LeJay. I don't remember LeJay being there that long, but me and Sharika Miss Ellaby, we were there the whole time.
All right. Now, this day on the 29th, this thing happened. Did anybody make any contemporaneous notes about what you guys had said, what's going on, other than the fact that you had this discrepancy in the money? The incident that happened with Mr. Blakely.
Mm-hmm.
Did anybody make any contemporaneous record of Ms. Gooden and Mr. Blakely got into an argument today about a perfume problem?
No, sir, I don't
That's
believe
the
so.
kind of thing that y'all make records of.
No, sir. I don't believe we made record of that on that day.
Okay.
No.
This incident about the money, what is the record keeping process about that? I know you had to make some kind of record. We got an overage today, got
Mhm.
$1,100. Somebody made some note somewhere about something, I'm sure.
Now, I didn't call the help desk, but as the lead clerk, I believe Miss Nikki called the help desk.
Miss Nikki did what?
Called the help desk.
Called help there.
Yes.
Is that somebody in the building or is that someone?
Oh, no, that's a remote, like a probably.
Problem solved.
Yes, yeah.
So you call them when you have a discrepancy or some issue and get some instruction
Right, yeah, when we can't figure it out. Yes, sir.
as to what to do.
Yes.
Did you do that?
No, sir.
You didn't do that.
No, sir.
Think Miss Nikki did.
She might have did because she the one that came up with where the money was going and who it was supposed to go to and all that.
Okay.
Mhm.
Now, the day after this incident happened, did Miss Gooden come back to work?
Yes, sir.
Were you there?
Yes, sir.
Did you and her have any conversation that day?
I do not believe so. Like I said, I'm sometimes on the floor, but I'm not always on the floor with them. But no, sir.
Okay. So did you and Miss Gooden ever have any conversation about, you tried to choke me, you put your hands on me improperly, and I'm upset because you made a improper touching on my person.
No, sir.
Y'all ever have a conversation like that?
No, sir.
All right. This grievance that she filed, to your recollection, when was it filed?
A couple of days after it was filed on September the 4th.
On September the 4th.
Yes, sir.
And explain to Judge Stack exactly what this grievance process is. Who's involved? Where does it go?
Okay.
They're making a big deal about this grievance. So tell Judge Stack, how does that work?
I'll say, so the grievance process is allowed for the employees when they feel like management has violated some type of standard in the like our guidelines and policies. So you have 14 days to file a grievance. So the incident happened on the 28th, 29th, and the grievance was filed on the 4th. Then you have so much time to get it to the next level if you have so much time to get it to the next level if the parties at the first level can't agree on it. So it is a timely procedure, but it was filed on the 4th of September.
Let's give Dawn a minute, because she's marking and and she's giving you the stink eye. So how do I know it? Because I've gotten that stink eye on many occasions. The court reporters can't talk and both mark stuff, and
I
we're really
understand.
bad about talking over them while they're marking it.
Sorry about that. I'm going to keep you, Miss Johnson, what we mark as defendants exhibit 1, which consists of what, 1, 2, 3, 4 pages. You recognize the document?
Yes, sir.
Documents, each one of them?
Yes, sir.
You've seen them before?
Yes, sir.
Now, not going into what they say, what are those documents?
Okay, so this document is basically just a grievance outline worksheet, and it is typed up by the union steward. And when there's a grievance.
Okay, so
Mhm.
these are the forms that the employees at the post office have to fill out when they want to file a grievance, right?
Well, no, it's not the form that the employees fill out. It's the form that the union steward completes once they complete a grievance.
Now,
Mhm. Well, not complete, but initiate a grievance.
I want you to look at the 4th page. Don't tell me what it says, but tell me what page 3 and 4 are.
Okay, page 3 is the resolution.
What is page 4?
The resolution, the step 2 resolution. So by this time it had made it to step 2.
Miss Good's grievance.
Yes, sir.
About the incident on the 29th.
Yes, sir.
Yeah, I'm gonna tender.
And this was dated September 26th.
Okay. Any objection?
The only objection I have is that the victim never saw this, never signed it, was never privy to it, and so therefore it can be admitted, but when she testified she was not privy to any resolution. She's not a signature on this.
All right, you can cross on that. All right, so it's tendered and admitted without objection.
Okay, so Ms. Johnson, this grievance in step one is dated what on the first page there?
September 4th.
September 4th.
That's when the grievance was initiated.
Okay.
Then they had a meeting September the 9th between the supervisor, Tamiko Banks, and the steward, LeJay Marshall.
Okay, so Miss Gooden talked to whomever she needs to talk to, filled out whatever she needed to fill out, and somehow this process got initiated on September 4th.
Yes, sir.
Do you know what's the process by which they have to tell Miss Gooden what they are doing?
Sometimes they don't, sometimes they do, but she would never have to sign off on anything. It will be between the meeting parties, which will be a member of management and a member of the union. So she would never have to sign off on any of the resolutions or anything like that. It'll be between the union and management.
Okay, so is it somehow the responsibility of the union rep or stewards or somebody to tell her what's going on with this stuff?
Well, they should tell her, but I don't know if it's their responsibility to tell her.
All right, so you don't know if they told her or not.
That's correct.
So they don't come back to you and tell you, well, we talked to Miss Gooden and we explained they don't do that either.
No, sir. No one came back and told me anything like that.
So after step one, then what? What's on the second page there?
Okay. Okay, so this is step 2, and this was between Miss Brenda Story, the clerk craft director, and the union president, Mitchell Taylor.
So is that the Brenda that Mr. Rico was testifying to a minute ago?
Yes, sir.
What's her position?
She's the clerk craft director.
Okay.
She's over Mr. Rico, he's over the city carriers.
Okay.
Okay, so you have unions, but each union representative is over different crafts. So Mr. Rico is over the city. Ms. LeJay deals with the clerks, and then we have one person that deals with the rural carriers.
So they're the union representatives for the folks in the field.
Yes.
All right. So this second step grievance that Miss Gooden filed, it went past step one and went to step 2.
Yes, sir.
All right. What happened in step 2?
Okay, so Miss Brenda Story, she met with the step 2 designee, which is, if you just look down, Mr. Daniels. He's the postmaster, and they came to a resolution.
Okay.
Mhm.
So what's the date on that?
September 26th.
Okay. So and what was the resolution?
You want me to read it? Okay.
Yeah.
The parties agree that management and the union will adhere to the zero tolerance policy. Management will treat the grievant with dignity and respect. Both parties shall take online harassment training within 15 days of this settlement. This is made in view of specific individual facts and circumstance. In this case, the parties agree that this is full and final notice of settlement agreement is made without prejudice to the position of either party. It is agreed that this agreement is not to be cited as precedent in any future grievance or arbitration.
So were you apprised of this?
Late after it happened, yes, sir.
Okay.
Yeah, because I had to do the online training.
So you had to do the online training.
Yes,
And what's the date on the resolution?
September 26th.
September the 26th. Less than a month after the incident happened.
Yes, sir.
And before you met with the people at the police department,
Mm-hmm.
the second time when they interviewed you and did the well, I take that back. When did you? Let me just ask you that question. When did you record that statement with the
Which statement?
with
The first one or the second one?
with Detective Carnegie that was here this morning.
Okay, that first statement was done in August.
Okay.
Yes.
The video.
Yes.
Okay.
with him and the,
in the union shop.
no, Jessica Spears, she is the, postal inspection service.
Postal inspector, I'm sorry.
Mhm.
So then you did a second interview with him at the police department.
Yes, sir.
All right, so the interview that I showed you that the state provided to us, which statement was that? Was that the first statement, or that was at the post office, or was that the statement at the police department?
That was the first statement at the post office.
That was the first statement at the post office.
Uh-huh.
All right, did they video the second statement, or do you know?
I'm not sure. I believe they did.
You haven't seen it?
No, sir.
All right. Okay, so you had to take some online classes about training.
Yes.
All right, so did they explain to you what you did by making this gesture toward her, putting your hands on her, making a statement? I'm going to show you that that was in violation of the policies, the ones that Miss Gooden introduced here this morning.
Yes, sir. They said that the gesture was, I shouldn't have made a gesture, and I had to just use better exercise and care, in dealing with employees, because as the postmaster OIC, the supervisor should be dealing with the employees, not me. I deal with the supervisors, and the supervisors deal with the, employees.
So it's basically stay in your lane and keep you in the chain of command.
Yes.
Now, Ms. Gooden made a big deal about you and people in Griffin. You guys didn't like her. When she got here, she was treated badly. You all had a bunch of incidents and little small things. You would speak to her and being rude to her. And this observation, you said she wasn't courteous to some of the, whoever the customer was when you were doing the observation.
Mhm.
Were there any previous grievances filed before August the 29th about, and you said she filed a grievance about her flex position.
Mhm.
Did she file any other grievances about any other work conditions in Griffin prior to this incident on the 29th?
Not to my knowledge, no.
All right. Did you have any discussion with her? Did she ever come to you and say, hey, look, I'm being treated bad out here. These guys don't like me and they harassing me. It's a hostile work environment. I'm getting ready to try to get out of here. Did she say anything to you about anything as such?
Not in that manner. The only issue she came to me is about her and the lead clerk not getting along. So that's why she would try to come to me with, revising her schedule. Cause like I said, I revised her schedule, to accommodate her. And then she wanted to revise it for the rest of the year. And I told her I couldn't do that.
Okay. Now, the question on the table here today is obviously one of Ms. Gooden's apprehension as to what you were about to do to her and your intention as to what you were about to do to her. Explain to Judge Thacker when you make this gesture, you had your hands, what was your intention? What were you trying to do? What were you trying to impart to Ms. Gooden?
Mm-hmm.
I'm gonna let you put it in your own words. I want to lead you here. So you
Okay.
tell Judge Thacker what you were doing.
Yes. So on that day, everyone was frustrated. The gesture was made out of frustration. It wasn't any intent to harm Miss Gooden. There's nothing I would do. For the past 25 years, I've never harmed another employee. I've been in management for the past 15 years. As a supervisor, and then as a postmaster, I've never harmed another employee. I, None of that. So the intention wasn't to harm her or create be violent towards Ms. Gooden. Because I stated previously, I've worked with her, on numerous occasions, in regard to her schedule, which something I probably shouldn't have been doing. But since she came to me, with her situation, me being the officer in charge and me being, a postmaster, they do tell us something, you need to work with your employees because they're the ones out there doing the work.
Okay. She with you, Ms. Sexton.
All right, let's take just a quick break and then we'll jump into cross.
Yeah.
So, 5-minute break, everybody. On your break, ma'am, just don't talk about the case with your attorney because normally
Okay.
we would just jump right in. But
Okay.
we've been at this for an hour and a half and I'll get everybody a quick break. So,
Okay.
just have the restroom. Don't talk about your testimony with anybody. When you get back, just resume your seat there. So again, 5-minute break, everybody. Just stretch your legs, go to the restroom, and then we're going to jump back in. All right, so I'm gonna officially call us back. Mrs. Kendall, you finished your direct?
Yes.
Ms. Sexton, so Ms. Sexton's gonna ask you questions now, ma'am. Sometimes these moments get a little heated. It's part of the process. Just take big deep breaths, make certain the answer not very loud because we're trying to make the record here.
Yes, sir.
Ms. Sexton, the floor is yours.
Okay. Ms. Johnson, my name is Eileen Sexton. We haven't been formally introduced, you sort of just have seen me around. I work with the state and I'm prosecuting this claim, and we've never met and we've never talked before. Is that correct?
Yes, ma'am.
Just a couple of questions. So I'm trying to understand at two different regrets. When you made the gesture, in your words, when you made a gesture, were you frustrated?
Yes, we all were.
Okay.
Mhm.
Were you all laughing?
There was a moment where we were laughing, but
So,
all of us, not just me.
so were you frustrated or were you laughing?
We were both.
All right. And you, as someone who's been with the post office for a very long time, and as someone who's in management, are you familiar with a site called Light Blue?
Yes.
Okay. Can you describe to the court what Light Blue is about?
Okay, light blue is where,
Wait a minute, John, excuse me, John. I can't understand a word you saying, Miss Sexton.
Okay, I'm sorry.
That's all right.
You know what, let me do this.
Yeah, that'll work. So
My apologies.
flip the mic on, move that to wherever you want it to. Clint will come help if you want.
Where's the flip? I'm sorry.
I can hear you great because you were up here by me.
Yeah,
That
but
makes
no,
sense.
that's fair. That's totally fair.
Oh, you're much louder. That's great.
My mom never told me that I should be much louder. As someone who has spent a great deal in their professional career with the post office, and as someone who's in management, are you familiar with a site called Light Blue?
yes, ma'am.
Can you describe to me what that site is about?
Okay, light blue is a site basically for all employees. It handles everything, well, a variety of things. E-reassign, you can go on there and look for jobs. You can also pull your paychecks up. You can pull up any records you have as far as bid jobs or it's just a normal postal website for all employees. They have different things on there. You can contribute to your thrift savings on there, which is our what you guys might call retirement. I'm trying to think all of the things that are on light blue. You can print your W-2s off of light blue. You can exchange leave on light blue. You can request leave from other employees on light blue. It handles a variety of things.
Okay, and do you also have access to Light Blue?
For myself, not for other employees.
So you're not made aware if anyone puts anything on Light Blue regarding a grievance. Is that what you're saying?
That's correct.
Okay.
But can I just say,
Yes,
Um,
absolutely.
grievances aren't put on light blue. You have to give that to the union steward.
Okay.
Yeah, now they have a form, they have a, you probably have to ask the union steward more about this, but when they're logging the grievances, they have where they go log them, but they don't log them on light blue. Light blue is like a administrative,
So perhaps in my naivete, I might have, is there a portal from Light Blue to someplace that you can go to file a grievance? Are you
No.
familiar with e-file UPS tracking? It like a e-file UPS. Are you familiar with that website?
Okay, that is on e-reassign. Yes, but I will only have access to me, not other employees.
Okay.
Yeah, because light blue is very sensitive there's a lot of time sensitive documents on there, so I wouldn't have access to anyone else's light blue because you have to have your own kind of like login and password. So that's yeah.
So if I understood your testimony correctly, and please correct me because I do not mean to misstate.
Yes, ma'am.
You basically said that you were aware of a grievance in that Ms. Gooding did not realize that she was in a flex schedule at Griffin, and there was a grievance.
Mhm.
And then I believe there was a second grievance about maybe there wasn't a there was a discussion with you regarding scheduling and with her daughter, and you already said that you weren't in charge of scheduling, but that you were trying to work it out with somebody.
Yeah, even though I'm not in charge of scheduling,
Uh-huh.
I can still revise someone's schedule if I feel a need to accommodate them when they have issues going on outside of work,
But,
you know,
and then to your knowledge, there was nothing else really going on that you were aware of. Is that correct?
not, what do you mean going on?
There were no issues between yourself as the person in charge of the Griffin Post Office
Mhm.
and Miss Gooding as somebody who was employed in the Griffin Post Office, except for the two issues regarding scheduling and regarding the fact that she thought it was something other than an E-flex position. Is that how you would
Right.
describe your relationship?
Right, but the grievance, the first grievance, it wasn't done aimed at me. It was aimed at her position.
Thank you for
Because-
that.
Yeah.
But it was a grievance, so
Yeah,
she
it
was
was a grievance.
unhappy.
Yes.
Okay, thank
Well,
you.
I can't say how she felt, but the grievance wasn't aimed at me. It was aimed at, she thought that she should have different hours.
Okay,
Because she saw something when she bid it on a job, she saw some hours, different hours than after she came to Griffin. So the grievance was in regard to just the procedure, not aimed at me.
okay. And I believe that's 100% true, so I'm sorry if I misrepresented
Oh, no, no.
anything other than that.
No.
I believe it had nothing to do with you, it had to do with
Her schedule.
her schedule.
Yes, ma'am.
I'm going to show you something. This is a grievance that was filed online by her
Mhm.
prior to this situation. And I'm understanding you to say that you were not aware of that. Is that what you're saying?
That's correct. Yeah, I'm not privy to that.
Do you have any objection?
No.
What number of that?
Well, objection to that right there.
Yes.
Well, who's going to lay the foundation for
Let-
I just laid the foundation. Was she familiar with the website that they were filing things on? What was it?
So hold on. Y'all are saying you're saying the same thing. You just don't realize it because, you're adversarial. So it's okay. She hasn't tendered it yet. She's just trying to put it up there. So it's going to be 8, I believe. Let's go off record. Is that right, Donald? 8? 7. Again, no, 7 was the transcript, but that was not tendered. So, but it did need to be marked. So 7 will be your transcript. 8 will be this grievance. This is why I stop and do this. Right. 7's in circulation, but is not specifically tendered. Okay. So what we're going to let you do. Sorry, I got ahead, Donna. Did it again. You ready, Donna? Okay. We're back on record. All right. So what we're going to do, Mr. Candelas, I'm going to let her move that around a little bit, show it to the witness. And then I'll make some decisions on it, when it gets to a more formal state of affairs. So, just hold that objection, for a few more minutes.
Yes, sir.
All right, Ms. Sexton, you may continue.
So I understand that you said that you don't have access. This is an employee by employee, but do me a favor and just look across the top at like the, whatever you call it, the Google address or whatever it is, the internet address, and then look at this and tell me if this sounds, if this looks like what you're used to. And my first question is the structure of that. Does that look like some, have you ever seen that address before? Are you aware of that portal through? I know it's hard to read. I tried to make it as dark as I could.
Is that e-file?
Yeah, it's e-file, but like you.
Okay, now this is an agreement. This is a EEO.
Oh, all right.
It's a difference. Yes, ma'am. Right here, it says equal employment opportunity. So this EEO was filed on August 15th, 2024.
Okay, and that would be before this incident, is that correct? Since this incident was August 29th?
Yes, yeah,
Okay.
but this is an agreement.
Okay,
Mhm.
but
And then it was another EEO filed
Wait,
on.
wait, hold it. You don't need to testify to what's in it.
Okay, okay, that's fine. That's fine. I'll answer her question.
Are you familiar with that? Like, does that look like something you've seen before? And it does because you just explained what it was.
Okay, so this is a e-file. This is a EEO. This is not a grievance. You say that this was a
And I
grievance.
just spoke.
Okay.
I apologize.
This is not a grievance. This is a EEO. So when employees file EEOs against management or another employee, it goes to this e-file, but I'm not privy to this until it's assigned to a counselor. And then the counselor will reach out to the person that they are stating and then goes from there. So no, I can't go online and see this.
That's what I understood.
Okay.
You just said.
Okay.
And I didn't mean to misrepresent it. My question is, you have, by looking at that, there was something that predated the incident. Is that correct?
Yes.
Okay. Thank you. Into that evidence.
All right, Mr. Kendall, she has tendered that document. Do you wish to?
Yes, I'm gonna object to that because there's been no foundation of what that document is. I
Okay.
mean,
It's
she was.
rebuttal to, there was never any problems before this.
Yeah,
It's a-
but if you want to introduce the document, it would seem to me, Young, that somebody's got to lay the foundation for the document, and is Miss Johnson certainly can't lay the foundation for this document.
Right. So what I'm going to do is I'm going to allow the testimony surrounding it to stand. I will allow it to be part of the total exhibits, but it's not going to be officially part of what I'll use to make my decision. I'll use what I make my decision off of the testimony that was given surrounding it. So you both get a little of what you want. I'm going to use the testimony from it. Mr. Kendall's going to keep it out. And so I'm splitting the difference on it.
So since this document's not coming in, I'm just gonna ask you, don't read it. Don't read it verbatim. Does that document make you aware that there was a problem in Ms. Gooden's eyes, anyway, not maybe in your eyes, in Ms. Gooden's eyes before 8/29?
Well, Young, excuse, she's still trying to testify to the substance of the document.
Yeah, and that objection is overruled. Don't tell me about the substance, just take her question in the most broadest sense possible and answer it if you can. So
Okay.
again, she's not asking you to tell me specific details on that document, and neither am I. But it is a valid question of what you knew or didn't know prior to the date of this incident. So partially sustained, partially overruled.
Okay, so in regard to the document, I didn't know there was a problem because when you file these type of things, you have to meet on them after it is filed. And no one ever met with me about what she filed on Light Blue.
Even subsequently, so that was filed and there was absolutely no action ever taken by EEO.
Yes, there was action taken. There was action taken,
So you,
but no one spoke to me about her filing this.
even though you're subject of that discussion, no one ever talked to you about it.
No one ever talked to me about it. The normal procedure is when you file an EEO, the counselor that is assigned to, they have to call you and set up a formal meeting. Okay? Now, let me just say this. No formal meeting was set up, but they would have had and arranged for her to be moved out of the office. So I didn't make that decision.
All right.
So the people over the EEO, they probably made that decision, but
And the date is prior to the incident.
yes.
All right.
I'm
And Ms.
guessing this is not allowed to be tendered.
Yeah, but if you'll leave it with Donna, because it'll still be part of the record. It just won't be part of the documents I use to make my decisions.
Okay.
And then,
So if I'm correct, you testified that your testimony was that the officer interviewed you at the post office.
Mhm.
And that was in August of in August, which predated your discussion with the policeman. Is that what you're saying?
Can you repeat that question?
Sure. Let's start off with something simple.
you testified, I wrote it down, that that the interview that you had with the post office inspector and the police officer occurred in August.
Yes.
Okay. Would it surprise you to learn that that actually happened September 25th?
Okay, so the incident happened in August.
Correct.
Okay. And the interview was done in September. You're correct.
Okay. Is there a reason that during that interview, you denied making the gesture, any kind of gesture or any kind of statement? Is there a reason you made that statement to the postal inspector and to Mr. Carnegie on 9/25 in a recorded interview?
Okay. So when they interviewed me, they really, I don't remember them asking me, did I choke her? But I told them that I did not touch her. And on that day, no, I didn't mention the gesture because like I said, it was some time ago. It's not like I was lying about it, but with everything that was going on, no, it wasn't mentioned that day. But he did not read me any rights that day. It was just, I thought it was kind of like an informal interview. And then he said, well, I'm gonna need you to come down. It got more formal. So I'm trying to,
But you were talking to the postal inspector. Would you not think that it was important to be candid with the postal inspector?
I
The
was-
postal inspector was the one that was actually conducting that interview. It was only at 3 minutes left
Mhm.
in each tape where he might ask an occasional question.
Yeah, I was candid during that time.
But you
Mhm.
denied putting your hands around her. You denied the gesture. You denied anything to do with this incident. As a matter of fact, you didn't even recall the incident.
No one asked me about the gesture. No one asked me about any gesture.
So-
No one asked me about, they just asked me what happened. If you go back to the recording, they just asked me what happened and I told them what happened. They never asked me if well, to my recollection, because it has been 3 years, if I put my hands on her. But that's what I denied that day.
So would it surprise you if you basically said that I don't remember anything, that was a long time ago, I don't remember those things
On what particular day now?
on that day? On September 25th, less than a month after an incident which caused the Postal Service and a police officer to come to your place of business and interview not only you, but co-employees, that you basically couldn't remember what happened.
I couldn't remember all the details. That's correct. It's not, I'm human, number one. And number two, with me dealing with just more than one employee than with Miss Kenya, I oversee 85 to 90 employees, the daily operations, 7 days a week. And it's a lot going on in Griffin. And under due stress and allegations, and when you've been working with someone and been kind to someone, and then just all of a sudden, boom. Yeah, I was under stress as well. So,
So,
you know,
so is a daily stressor that a post office inspector and a police officer show up at your office and are
No.
recording interviews?
that's
Is
not
that-
the norm, but that is a stressor for anyone.
To the point that you can't remember what? Is this such a frequent occurrence that you can't remember this
No.
kind of thing?
No, it's not a frequent occurrence, but like I said, I am human and I'm not, it happened more than, and I wish I would have notated that day, but I am getting older and sometimes I have to jot down notes when but that's like wasn't trying to leave out anything. And as a matter of fact, I cooperated fully with Investor Carnegie. He didn't have to, push me to come down there. I went on there on my own. And I also, with Ms. LeJay contacting the third assessment team, I contacted them as well.
But you refused to provide a written statement to Officer Carnegie.
That's not true.
Okay, that was his,
That's not true.
all right.
Because I gave a written statement to Ms. Spears. And on that day, he said, well, you know what? I'll just get your statement later. I never refused to give him
So
a
you
written
never told
statement.
him you wanted to talk to a lawyer?
No, because I went through with a full interview with him. I went through a full, it was about 45-minute interview with him. And I could have said, hey, I don't want to talk to you. I need a lawyer, but I never did that. I didn't contact a lawyer till he told me that I would have to turn myself in. So, no, that's not true.
Is it your testimony that you treat all of your employees even-handedly?
To my best, yes, I do.
Okay.
Yes.
Is it your testimony that the Griffin post office is a wonderful place to work?
What do you mean by wonderful?
People get along, the work gets done.
Well, the work does get done. Everyone doesn't get along, but that's every office you go to, every facility that I've been with, that I've been assigned to, everybody doesn't get along. Everybody doesn't get along at every facility because you have different personalities, you have different backgrounds, you have different beliefs. So I can't say that everybody gets along, but we do come together and get the work done.
Is it your testimony that you did indeed say, I could just choke you?
No, ma'am,
What is your testimony?
that I did not say that.
All right. Is it your testimony that you made a gesture with your hands in the proximity of the victim?
I did make the gesture, but it wasn't in the proximity. As I testified earlier, it was when she was walking up on me, not walking up on me, but when she was approaching me, then that's when the gesture was made. But no, we were not in close proximity.
So it would not be your testimony that it was not the victim coming up towards you, but rather the end of the day and everyone just kind of walking together towards the exit.
No, because on that particular day, me and Ms. Ellerby were already at the supervisor desk, and I still had about 2 or 3 hours to work. So we weren't leaving for the day, me and the supervisor. So we were not leaving for the day. The only person that was leaving for the day was Ms. Gooden. She was leaving for the day.
Okay, that's all I have, Your Honor.
All right. Additional questions, Mr. Kendall?
Yes, you come on down.
All right. Ma'am, you may resume your seat. Thank you so
Okay.
much.
Thank you.
All right, Mr. Kendall, do you have any additional witnesses you wish to call?
No, sir.
You rest.
I have a rebuttal witness, Your Honor.
All right. All right. So the defense is rested. State may call rebuttal. And then Mr. Kendall, if he wishes, will get us a rebuttal. Who's your rebuttal witness?
Mark?
Will this be
Yep, what's his last name?
Blakely?
I'm sorry, Mark Blakely. He should be upstairs.
Mark.
He was on the witness list. Blakely, he was also subpoenaed. He was on the witness list and he was subpoenaed.
He should be upstairs. All right, if anybody needs to step to the restroom while we're, go ahead
It
and do
should be
that.
short unless there's,
Yeah, that's fine, but Clint needs a minute to go.
no,
get
no,
his.
no, I'm just saying for your edification.
record. So the defense is rested. The state has called a rebuttal witness. What is your name, sir?
Mark Blakely.
All right, Mr. Blakely, I'm gonna hand you off to Ms. Sexton and she's gonna swear you in and take it over from there.
Okay.
Mr. Blakely, my name is Eileen Sexton and I'm the solicitor for the county, the state county of Spalding County. I'm gonna ask you to raise your right hand and I'm gonna swear you in, okay?
Yes.
Do you promise? Do you swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right. Can you speak into the microphone nice and loudly? Because our wonderful court reporter is going to try to take down everything you say, and that's going to be a lot easier if you talk into the mic, okay?
Yes, ma'am.
That's good.
Can you provide the court with your full name and spell the full name?
Markecia Blakely, Markecia. Middle name Delnico, Delneko. Last name Blakely, Blakely.
For the record, I'm glad I asked you to spell. That's all I'm saying. Sir, can you tell me who you're currently employed by?
The United States Postal Service.
How long have you been a United States Postal Service employee?
Probably going on like 11 years now. 11, 12 years now.
And did you work at any offices previous to the Griffin office?
Yes, ma'am.
And can you just give us a very brief history of where you?
I started off in Sonoya. When I started in Sonoya, I ventured off to Peachtree City, Tyrone, Georgia, McDonough, Peachtree City, McDonough, Tyrone. Then I worked in College Park. And then prior to Griffin, I worked in Atlanta, main office for 4 years.
Okay, and did you always work in the same capacity for the Postal Service?
I always worked as a clerk. Yes.
All right, and when you began your work in Griffin, were you a clerk?
Yes, ma'am.
All right, and how are you currently employed?
I'm still employed with the United States Postal Service, but I'm a custodian now.
Can you tell me why that happened or what your choices were, if you would explain to the court?
Well, I changed positions because I feel like I was getting harassed as a clerk by a lot of my coworkers.
And can you explain in very finite terms, very concrete terms, what that harassment would be, what it would feel like?
I would say like 3 weeks in, I started making complaints to Mrs. Johnson about the staffing of the T7 and other clerks that I was working with on the window. Like the harassment, the bullying, talking to me like I was a kid, the unfair treatment for the holidays. I was scheduled to work every holiday. And then I had found that in the union book, when it's all staffing for full-time staffing, because I had been in the post office when I came to Griffin for at least 19 years. So I had found something in the union book saying that if we all was regular full-time, that it would start with the junior person first, then it would rotate. And then I was told that wasn't true, and that was an old union book.
Okay, did you have opportunity to work with Kenya Gooden?
Yes.
Could you describe to me what she did at the post office? Just very briefly.
Briefly, I think I met Kenya in Atlanta. We just passing by the window and things like that. And then I met her in Griffin, like physically, met her in Griffin. I was on the window one day when she came in, and I went and got Ms. Johnson for her. She was, I guess, looking for, the position in Griffin. Because we all was getting access out of Atlanta due to changes. So we all either have to find somewhere to go, or we access 50 miles from the local office that we was at.
Did you ever have any discussions with Miss Gooden about the position that she was accepting at Griffin?
No, I was trying to tell her to come aboard because we was kind of short-staffed it. Well, I met her when she came in, and I just, gave her a little brief, like, what it was like, and I went and got Ms. Johnson for her.
Okay. And if there was bullying going on at that particular time, why would you have encouraged her to come?
It was a postal service. It was work. I can't really say. She was. I don't know. I didn't actually know what area she stayed in. Me, it was good for me for Griffin because I live in Griffin. So I was driving 45 minutes to an hour back and forth to Atlanta for 4 years. So when I pulled the position for Griffin, I thought it would have been a good fit because I'm right up the street from Griffin. I live in the 224 area. I didn't specifically tell her to come to Griffin. I just was like, we need clerks.
Okay, and
Did you ever get spoken to about lunch breaks?
Yes.
And what would that consist of?
I felt like I was getting picked on with the lunch breaks when I witnessed a clerk taking like an hour, 45 minutes, and I brought it to management attention, like, well, why am I getting 30 and why she's getting 140 an hour, 45? And they told me that her breaks was combined. And then I noticed the difference because like, well, she takes a break in the morning, like y'all ain't monitoring that. So I brought it to their attention, the unfairness about the breaks.
What about workloads or being pulled off of a particular area?
Well, it did come to a part when I was getting harassed and I had went to Mrs. Johnson. The T7, she had made a board and she had my name on every duty. Now, we as clerks, we all take a contract. We all pretty much have the same duties. As you know, cause the mail, it's just you really just work in the mail. Get the mail up in a good time, get the carriers out. I had noticed that when I had a small disagreement with the T7, that she had put me on, and I took a picture of it because I had sent it to a union rep up in the city and was telling them, since when we have a board with our name on it, and she has my name on every detail duty, and it's 5 clerks here. And I brought it to Mrs. Johnson's attention.
What did she do?
Ms. Johnson, she talked to Nikki about it, and then she told me kind of like, don't worry about it because I knew my duties. I mean, I had been with the post office 10 years, had nothing changed.
Were you ever a witness to any kind of unfair treatment or bullying of Ms. Gooden?
Yes.
Could you describe that to me?
From the T7, from Larita, I think that's her name, Larita. She was the T7 in charge. She was the worst one of them all.
Okay.
They call her Nikki Campbell.
And what would that bullying look like?
The monitor of the breaks, like when we could be doing some particular, just the harassment, talking to you like you're a child on the back of your heel, when you can see other clerks over here lollygagging or having a good time, and then you see somebody working, but then you come and pull them to do something else. It was just the nitpicking, but the same thing she had went through, I had went through prior to, me being there a year before her.
So would you say that there was a jovial atmosphere between Ms. Gooden and any of the supervisors or Ms. Johnson, or would you say that it was a tense environment?
It's a very tense environment.
I think what is your current position with the post office?
Custodian.
Can you explain to me how you went from a clerk with many years' experience to a custodian?
Yes, prior to coming to Griffin, I got an award for clerk for my speedy service and communication with the public. When I came here, I was doing passports. I did plenty passports in this city of Griffin. I switched over to custodian because of the harassment of the clerks there. I just couldn't seem to fit in with the clerks at all. I couldn't do nothing right. I went to Ms. Johnson crying. I've cried to her plenty times about the fair treatment amongst the clerks. Like I literally, 46-year-old man crying to his boss about the treatment on the workroom floor. I have never witnessed nothing like that. Griffin was the worst office I've ever been to. Out of all the years of, it was just the worst. It was just the worst. It was the worst experience ever. So me crossing over to the custodian, I thought it was gonna be a better fit for me. But now I'm out on the 14-day suspension now for being a custodian for using the products that the post office provide from a clerk that I ran from on the window.
So explain that to us, the specificity about a product.
Yeah, but we're gonna move on. Move on to the next two. Objection sustained. Next topic.
So why are you being suspended? Why were you suspended?
They said I was talking loud on the workroom floor.
I'm not what the rebuttal is here. What?
Okay, hold on. Okay, so his objection is that we've moved past the scope of rebuttal. Rebuttal is for responding only to Miss Johnson's or the defense's case, which was in this case was Johnson. So so just take a second, take a breath, ask your next question so that you elicit an answer that's a relationship to Miss Johnson's testimony. Go whenever you're ready.
It's my understanding that you were not there on the day in question, which was 8/29, where there was an incident. I just want to be clear, you were not there. Is that correct?
I was there that morning. I had went to lunch when the incident happened.
So you were not present in the building when the incident happened?
Absolutely. To my understanding, yeah. Because when I came back from lunch, that's when the coworker came up to me and told me what happened.
Okay. And I think that's all I have in mind.
It's a very hostile work environment. It's very hostile.
All right. Thank you, Mr. Blake.
Thank you so much.
Mr. Kendall might have some questions for you.
I don't
So
have questions, John.
you don't have any questions? All right. So what that means to you, sir, is you've completed your obligations under the subpoena. You've finished all the job I need you to finish.
Okay.
So you are free to go or stay as you see fit, but you are released from your obligations here.
Thank you,
All
sir.
right. Thank you so much. Okay. Any additional rebuttal witnesses?
No, Your Honor.
All right. Mr. Kendall, you have the right to call any rebuttal, including your own client if you wish.
No, sir, I don't have anybody.
All right, then I'm going to find that the evidence is closed. Now, you all scrubbed this baby pretty clean in your directed verdict arguments, but obviously I would love to give you the opportunity to jump back in. Ms. Sexton, you have the right to go first, last, or both? Last, okay. So Mr. Kendall, if you will sum this up for me, and
Yes,
once
sir.
y'all finish your argument, I'm gonna take a couple minute break, take my notes back to my chambers,
Yes,
go
sir.
through them, and then give you all a decision pretty quick.
Your Honor, I kind of summed it up in my previous motion, and I think at this point, I'm not quite sure what the state is trying to get here today. This appears to me to be a job action masquerading as a criminal case. And these complaints, these EEO complaints that Ms. Sexton is trying to bring up, this hostile work environment that she's trying to bring up, that's all fine and dandy if we were, in civil court and this was a civil action for damages about a hostile work environment. But they have escalated this thing into a criminal case because Ms. Gooden did not get the necessary results that she wanted from any of these job actions that she has taken. She was only in this office for like 3 months, and she's filing EEO complaints, and it's readily apparent that she wants to go and she doesn't want to be here, and she's trying to come up with some sort of justification apparently for the post office to move her, which I find it quite strange that after she left, she's right back in Griffin. Now she tried to maintain that she was forced to come back to Griffin. Now I don't know exactly how the post office works, but it would seem to me that if I'm in an environment where the officer in charge has threatened to strangle me, and I'm afraid that I might get strangled, that the post office will have a pretty difficult time trying to send me back to Griffin to work in the office where somebody has threatened me and I'm in reasonable fear that I am going to receive a violent injury. I think the whole thing, Judge, is just an attempt on the part of Miss Gooden to abuse the criminal process. And this is not a criminal action. She doesn't have any reasonable fear that she's going to receive any violent injury today, yesterday, August the 29th, 2024, or any day in between at the hands of Miss Johnson. They spent an enormous amount of time here today talking about perfume, talking about money being mishandled, talking about everything under the sun, except how reasonable was Miss Gooden's apprehension that she was about to receive a violent injury. Nor have they talked about or tried to maintain that they have any evidence that Ms. Johnson intended to commit a violent injury against Ms. Gooden. It's merely a job action. That's where it should have stayed. That's where it needs to go back to. And all these complaints that she and Mr. Blakely and everybody else has about the Griffin office, the environment at the Griffin office, this is the improper forum for them to be trying to air all of their grievances. And if she's dissatisfied with the grievance process and she's dissatisfied with what the post office did in terms of sending Ms. Johnson to get some training, that's her prerogative. That's all fine and dandy. But trying to abuse the criminal process and elevate this into some sort of criminal event seems to be beyond the pale. As I said a few moments ago, I've been doing this an awfully long time. Probably too long. And I've seen almost everything under the sun in these 45 years. But I cannot recall ever having to come to criminal court because somebody allegedly made a gesture and I thought I was about to be strangled, but I went back to work the very next day to the very same place that I was about to be strangled in. That seems to me to be a bit far-fetched. Now, I don't generally, as a practice, try to tell prosecutors how to do their job, because I have a job, they have a job. They get paid much more than I do for doing their job than I get paid, but that's my fault. But to drag people through all of this as a criminal case, when everybody over there who witnessed any of this have told the prosecutors that this was not a criminal event, that there was no intent on the part of Ms. Johnson to strangle, choke, or commit any other violent injury to Ms. Goodson. But they continue to try to prosecute this case, irrespective of what all the witnesses that they subpoenaed had to say about it. I find that a bit troubling, because we are supposed to be here trying to find justice in these things, not just simply going through the motions. I understand that they have victims who have rights, and victims have to have their rights protected. But at some point in time, all of us, as officers of this court, officers of any court, have to exercise some discretion and not allow people, just because they may be vociferous, and just because they may, that was a big word there I did use, okay? Just because they are standing on the table for a long time and they are demanding prosecution does not dictate that we have to go through this process. I think this case is way overblown. I think Ms. Johnson was completely out of place, making any kind of gesture, making any kind of statement, because Ms. Johnson knows full well, after working for the post office 25 years, she's well aware of that standard of conduct that Ms. Sexton presented. And that kind of talk, that kind of gesture, that kind of insinuation is completely antithetical to the post office policies. They call it a zero tolerance policy. And as well it should be. Having said that, just because you violate the post office's zero tolerance policy does not make you a criminal. It may make you get fired. It may make you to get yourself and your butt sued. Be that as it may, this case is going way too far for way too long to satisfy Ms. Gooden and her continuous complaints that this case get prosecuted. She needs to go back down there, and if she wants to sue the post office, she wants to sue Ms. Johnson, she wants to sue anybody else over there, there's a perfectly situated forum for that. However, the State Court of Spalding County is not the place to air all those grievances. Our contention here, Your Honor, is that there has been no evidence that she reasonably thought that she was about to receive a violent injury. They really undermined their own case by not charging this as a battery, because if they actually thought Ms. Johnson touched her, it would have been a very simple matter to come in here and charge her with a battery, which they did not do, because they don't believe Ms. Goodson. And if they really thought that anybody else over there saw any of this or thought it was a serious matter, they would have called them as a witness. But after Ms. Sexton saw those videotapes and what she saw in those videotapes, she very quickly, because I got them Friday and here is Tuesday, and she has jettisoned all her witnesses because she knows that there was no intent on the part of Ms. Johnson, and nobody that was over there, that Ms. Johnson was trying to commit a violent injury to Ms. Goodson. And on that basis, Your Honor, I think we are entitled to an acquittal on this assault case because there is no intent and there's no reasonableness on the part of Ms. Goodson that she was about to receive a violent injury.
All right, thank you, Mr. Kendall. All right, Ms. Sexton, the floor is yours.
I find it a little interesting that I'm being accused of not putting these subpoenaed witnesses on the stand who would apparently be quote unquote bad for my case when I have handed to Mr. Kendall on a silver platter all the witnesses that could support his case on a silver platter, subpoenaed them, have videotapes for them, and I've handed them over to him if they're so terrible. And yet he has not called one single witness. Is it because of efficiency and expedience of time? I haven't heard anything like that. However, what I will say is that the reason that those witnesses were not called is because I have impeachment evidence on every single one of those witnesses, and he knows it, and that's why they weren't called. So I am not going to sit here and take the brunt of the insinuation that I should not be pursuing this claim, because all of the information I have is that these witnesses would cause this situation to result in an acquittal. It's the exact opposite. I am foaming at the mouth to have these people up here so I can impeach them with the evidence I have. Now, why did we talk about the perfume? Why did we talk about the overage? Because if the defendant had put in all the evidence that there was about all the grievances, every single one of them started with impugning my victim because of these two errors. The grievances started with, this is what happened. So the best defense is a good offense. I'm putting it up. I'm putting up what happened because I can sit back and wait for them to put it up, but I don't want to do that because every single grievance starts with that information. Why? If it's not relevant, if it's not hurting my client, if it's not trying to paint a picture for the post office, why put it in the grievance? My person, my victim, was not in charge of writing out those grievances. The post office wrote out those grievances. They started with her issues, her problems, her mistakes. That's why we're testifying about it. Otherwise, I would go straight to, why did you put your hands around my client? Now, let's talk about not issuing a battery versus an assault. A bird in the hand. I can prove assault every day of the week because not only did the defendant admit it, but every single other witness admitted that there was a gesture that was close enough that they could have seen her potentially with her hands around her neck from various angles. They didn't see, quote, skin to skin contact. Why am I going to go for something when this is a slam dunk? Every single person says that they saw her make the gesture and make the statement. Now, I think it's interesting. My witness, my victim, is being accused of blowing this all out of proportion, blowing this out of the water. My victim is the only person who hasn't changed her story. My victim is the only person that immediately told her representative that same day that this happened to her. The same day. She told Lachey Marshall the same day. Lachey Marshall was the union representative. Interestingly enough, she is not here. Now, why? Because I would be able to impeach her. So I am telling you that the evidence is clear. The officer felt that he could trust the victim. He felt that he knew from the previous situation that the defendant had previously testified that she could not remember doing any of these things. And several days later, when she's in the police officer, she admits to doing this. His report also says, and it's in there, that she did not want to give a written statement. The reason that I bring in the evidence from Mr. Blakely is because everybody would have you believe that Miss Gooden is contriving this whole thing to get out of this office. She's not happy there. She has been trying her level best to get out there, and she will lie. She will sell her mother. She will exaggerate to get out of that office when all she's ever done right from the beginning is tell the truth. And she told the truth about what that work environment was like before this incident. And the testimony from the defendant is that there were no problems. I mean, just normal sort of problems. We have a man who was brought in here with sort of peril to himself because this probably isn't going to go over well. And the reason he's testifying about the 14-day suspension, which was being objected to because it was too wide of a berth, I was trying to show bias because somebody might say he was up here and he had a bone to pick and he had a grievance, and because he was on a 14-day suspension, and that's not why he's here. He's here. So the evidence from the officer is that he believed that, that there was probable cause to charge for a simple assault. We have evidence from the victim. I have no idea how this is supposed to be a directed verdict. The victim testified that she was afraid. She testified that she was apprehensive. She testified that the defendant put her hands around her throat. She testified that she said, "I could just choke you." So we have evidence from the officer, evidence from the victim, evidence from Miss Blakely. And quite frankly, if all of these witnesses that I handed to Mr. Kendall on a silver platter were here to support this story, one wonders why they're not here. I don't, because I have all kinds of impeachment information. Oh, as far as going back to the office, so the victim has a career with the post office. She has a child to support, and she called the union representative when it happened and said, "I don't want to go back to work." And the union representative said, "I got you. Don't be afraid. I got you." And by the way, when she went back to work, she testified that that was not true. And so as soon as she got there and Miss Johnson approached her when she was told that Miss Johnson wouldn't be approaching her, she went out. So this whole, if you're terribly in fear of your life, you wouldn't go back to the Griffin post office, that's a misrepresentation of what happened. She was assured she could go back safely. She went back. When she couldn't go back, when she felt she wasn't safe, she left again. If somebody approaching you in a hostile work environment that you don't have a good relationship with, who is superior to you, comes up to you, puts their hands around your neck, in the alternative, comes close to you with a gesture and says, "I could choke you," I have no idea why a reasonable person would not be afraid of that. Choking is a very violent action. I believe that we have satisfied the burden of beyond a reasonable doubt from all of this testimony. And the state is requesting that the defendant be found guilty of simple assault, which is when a person commits the offense of simple assault when he or she either, okay, that doesn't matter. 2, commits an act which places another in reasonable apprehension immediately of receiving a violent injury. I believe the state has proved their case, and through the evidence, the state asked for the court to find the defendant guilty.
All right. Okay. Any other housekeeping before I go back in the chambers? Ms. Sexton, we'll start with you.
No, Your Honor.
Mr. Kendall, any other housekeeping before I go back in the chambers?
No, sir, Your Honor.
All right. Well, then what I'll do is I'm gonna put us in recess. I think Donna, you have all the exhibits, right? You have all the exhibits. All right. Piper, are there any exhibits on that table? Okay. All right, you two look at these exhibits, make sure they're all correct before. All right, and then as I go back into chambers, this, yeah, I'll send these. Thank you, Don. All right, and you ready? I got a few more odds and ends. I still want to talk until you gave me a thumbs up. All right, we have witnesses upstairs. They can be released.
Yes, Your Honor.
So Clint can go up and tell them they're all good to go. And Clint, you'll tell them, please tell them that they're welcome to come to the courtroom or they're welcome to go home or whatever. What they do next is up to them as long as it's legal. So, all right, what I'm going to do is I'm going to step off the bench then. I'll be back out. 15 minutes or so, 20 minutes or so. That'll give me enough time to look at my notes, look at the case law, look at the statutes, and make my final decision. So I'm planning on being back out here at 4:30. So, all right, I'll see everybody in about 20 minutes. Patience on that. Obviously, y'all gave me a tough case. You're aware of that this was a tough case. This was a difficult decision. And I wanted to explore all of my options, which is what you've been seeing me type on as we go. All right, so here is my decision. So what I've done is it's not quite what any of you all are probably about to expect. So what I've done is I've written up here, and follow me to the end of what I'm about to say. So nobody get excited or really mad until I finish what I'm saying. As to the simple assault charge, the criminal simple assault charge, I've decided that there isn't a sufficient amount of evidence for me to find beyond reasonable doubt that she's guilty of that charge. But what I did do is I said that there was enough here for me to explore a state disorderly conduct charge. Because those are very similar elements, and disorderly conduct is a lesser included. And then I looked at that one a long while and realized that Spalding County has identical language in our county ordinances for disorderly conduct. And our disorderly conduct charge for our county ordinance is 11-1003 B2. It's identical language to the disorderly conduct charge of the state. And when those two languages are identical, I have the authority to move seamlessly between the two. It's when those languages don't match that is there. Because my finding of this, and I took 15 pages of notes. So just so y'all know that during this trial, I took 15 pages of notes trying to make certain that I was tracking what each of you all were trying to have me hear. And I hear both sides of this very clearly. I hear the toxic work environment. I've worked in toxic work environments where you just feel like it's a powder keg waiting for something to go boom. I've also been in charge of things that are going sideways, and you're trying to figure out what to do with them. And I've said things that I've regretted, not to this extent, but at the same time, I can see how this got to where this is at. And I know she denied saying it, but I'm saying I think something happened. And I think something happened that was the end of a very bad day that appropriately led to this moment for me to make this decision. But at the same time, I didn't feel like it was proper for this really bad moment to create and otherwise create problems and otherwise derail a long extensive career with the United States Postal Service or whatever may happen next. But at the same time, Ms. Gooden did deserve to have me hear this and did deserve me to say that, yeah, something happened and we need to address it. So my finding is I find that beyond a reasonable doubt, there is sufficient evidence at the conclusion of this trial for me to find Ms. Johnson guilty of the Spalding County Disorderly Conduct Ordinance, which is not a criminal conviction. It is an ordinance conviction. And the ordinance, again, is Spalding County Ordinance 111-1003 B2. B as in Bravo, 2. And if you read that, it is the identical language to the disorderly conduct charge, paragraph 3. So if you all are trying to track those two against each other, you're looking at paragraph 3 of the state disorderly conduct charge versus paragraph B2 of the county ordinance charge. Ms. Sexton, am I correct that I heard that they're still working together in the post office down the street?
There is currently a bond which prevents that,
Okay.
prevents contact.
So tell me about how this is currently structured, because that was the only thing I didn't quite have straight in my head. And I'm going to hear from you, and then I'll let you tell Mr. Kendall, and then Mr. Kendall fill me in.
So I'm actually, because there seems to be a lot of moving parts and I do not want to misstate it, I'm going to ask Ms. Gooden to say what it is because I don't want to misstate it.
That's fine. And then I'll let Mr. Kendall talk. So Ms. Gooden, this isn't like a testimony part, but I'm trying to craft a solution here that provides a structure for peace going forward. Tell me your current work environment and how close it does or doesn't revolve around Ms. Johnson.
Yes, sir. So I was forced to go back to Griffin
Go ahead, Clint.
until
Just grab that mic and
case-
pull it up. It just needs to get closer.
until the case was done to see what the verdict was. From this point on, I'm not sure how they would go about moving forward. So far as me, and I'm assuming that if she's guilty, then she can't work within my facility where I am.
And you're currently in Griffin?
Correct.
Okay, Mr. Kendall, talk to your client real quick and then fill me in on what this looks like from her perspective. Because I may take no action. I may just let the US Postal Service work this out because they're both subject to the units, not the United States Postal Service. And I'm just telling you all of the different ideas I have up on my head of how much I am or am not gonna get involved in this issue. All right, let Ms. Kendall go ahead.
Ms. Johnson currently is at the Forest Park office now. What's gonna happen?
Since September.
To what?
Since September.
Until September.
I
and
mean,
then-
I've been here since September.
You've been there since September.
Mhm.
So what's supposed to be going on now?
Um,
I mean, what's supposed to be putting on, what's?
9 times out of 10, if I go to my boss and say that, I don't really want to be in Griffin any longer, she may just let me stay in Forest Park.
Okay,
Because and if Forest Park is closer to my home, and if I tell them I prefer to be in Forest Park, I really have no interest to go back to Griffin.
okay.
Yeah.
All right. Thank you. Thank you. Ms. Sexton, anything else?
No, the only thing that I know is that, it's my understanding that the Postal Service is not dictating what happens, and that the bond was the only thing that dictated what happened.
Okay.
That's my understanding.
And given that I chose the ordinance option, even if I were to do something very heavy-handed, I only have 6 months and they have the rest of their lives together. Okay. Well, then what I'm gonna do from this point is that I'm gonna let them use the levers within the United States Postal Service to work out their options. Obviously, there's a post office in every town around. They're gonna need to work that out between them. So, Ms. Johnson, as I have found you guilty of even the reduced charge, you do have the right to appeal my decision. You have 30 days from this moment if you wish to appeal that decision. You can speak with Mr. Kendall if that's what you wish to do. You also have what are called habeas rights. Habeas rights are where you may sue Spalding County civilly over in Superior Court to challenge this conviction. And from this moment forward, you have 6 months to use those habeas rights before they expire. So you have multiple pathways if you wish to challenge that. And I would just refer you to Mr. Kendall if you have any additional questions on that.
Yes, sir.
All right, Ms. Sexton, anything else?
I don't believe so. Do you have any questions?
You can ask Ms. Sexton if you have any questions, and Ms. Sexton can translate them to me.
You would like to keep what? You can't do that. You can't keep the original. Stay away. Not under this. Your Honor, is there a chance for the 6 months under the municipal?
So, I mean, that's part of what I'm sitting here looking at is that I thought about it. The answer is I thought about it. I thought about it a lot. I thought about it all day long. But the fact is that there's no scenario where I think no conduct is the appropriate result because they're still going to be working in the same environment. And the US Postal Service is a humongous organization. And I'm just saying they need to work that out with them. So I also know that if Ms. Johnson doesn't act appropriately, then frankly, we're going to be right back here and I'm going to show zero mercy because I'm going to be like, why are we right back here? And so my position on it is that if something goes wrong after this, I will have all the tools I need to take care of this in a very expedient manner. And I trust that Ms. Johnson is not going to subject herself to that. So y'all obviously both have futures ahead of you. You both have careers ahead of you. You both have lives ahead of you. And I'm trying to set this up in a way where, frankly, what it does more than anything else is gives you all the ability to move differently. And so like Miss Gooden, you now can go to the United States Postal Service and say, the court did find her guilty of disorderly conduct. I need space from her because I am officially a victim in this case, and the court did officially find her guilty of a lesser of an ordinance. You get the ability to say, I've not been found guilty of any criminal law, any Georgia state criminal charge. You've been found guilty of a county ordinance. And that's what I'm trying to give both of you is the ability to move your way through this in a very uncomfortable way, but a way that gives both of you a pathway forward out of this. So if you're both mad, then I've done my job right. Okay. Mr. Kendall, do y'all want to come look at this my verdict form? See if you wanted me to make any changes before I hand it to Ms. Carly.
I just want to say one thing,
If y'all want me to make any changes, amendments, clarifications, I don't even know. Did I write fighting words on there? That's what I meant to write.
Fighting, I didn't see fighting. words.
Okay, I need to add that. Did I put that on there?
No, sir.
Okay, I meant to. All right, well then that. All right, Mr. Kendall, what else?
Like I said a few minutes ago, I've been doing this a long time. And I don't know if this was your idea or Mr. Hope's idea, but this is about the smartest thing I've seen in about 45 years. So I want to just say, out of everything that possibly could have happened down here, I'm just so, I can't believe I didn't think of that. But whoever thought of it.
Good judges have
is
good
a
staff
brilliant-
attorneys. That's all there is to it.
brilliant barrister, and needs to get, I need to get promoted to the Supreme Court.
I have excellent people around me and they make me look better than I deserve. How about that, Mr. Kendall?
Whoever, they did a good Christmas present, John.
All right. All right, Ms. Sexton, anything else?
No, I think we're good. now.
All right, Mr. Kendall, anything else? Okay. Again, I appreciate the trust both of you placed in me in letting me make this decision. Obviously, both of you have the right to a jury trial, and if either of you had flexed that muscle, you would have gotten a jury trial. So I just wanted to say thank you to you, to both of you, for giving me the trust to place in this. Again, Ms. Gooden, don't forget that you have this decision gives you leverage or authority. I don't know what the right word is in the United States Postal Service, but it gives you the ability to let them know that you need certain things from them. And it also protects Ms. Johnson from frankly losing what may be her career track here and let you continue doing your stuff. And obviously, if you don't want to come back to Griffin and she stays there, that's my ideal setup, but I'm not controlling that in any way whatsoever. You'll notice I have not sentenced you to any probation or a fine. I'm trusting that frankly, this is the solution that closes all of this out for all of you. Okay?
Yes, sir.
All right, that's it. Court's adjourned. You are all free to go. Deb Piper's gonna, Kendall goes out first and then Sexton, when they're all done,
Yeah.
you can take your lady out. All right, court's adjourned.